first NFT trademark trial just happened this week, and in this video I'm going to give you the rundown of what exactly is happening and why. And if at the end of the video you enjoyed it, don't forget to like, comment, and subscribe. The question of today will be, whose side are you on? And as always, never take anything I say as legal advice. Alright, let's begin. Let's start with the parties involved. Sorry, future Eduardo here. I recorded this before the trial verdict and then the verdict came out as I was editing it, but everything I'm about to say still applies and I added the verdict at the end of the video. Alright, let's begin for real. Hermes International, the French luxury brand, is suing digital artist Mason Rothschild for Mason's Meta Birkin's NFTs, which Hermes is claiming is infringing on their trademark since it depicts digital images of their famous Birkin handbags, although in a cartoonish fur instead of leather. He created and sold the NFTs in late 2021 after an extensive marketing campaign through his social media and website. He first sold the NFTs for about $450 each, but like all NFTs last year, their resale value rocketed to tens of thousands of dollars. A blockchain expert testified during the trial that Mason made around 52.2 Ethereum, which is worth about $87,700 today. Also, court documents state that Mason's Rothschild's real name is actually Sonny Alexander Esteval, but almost all the court documents address him as Mason's name, so I'll stick with that for the rest of the video. Anyways, 100 Meta Birkin NFTs were released in late 2021 at the Art Basel Fair in Miami, and Hermes filed suit in January of 2022. Without going too in-depth, NFTs are, to put it simply, digital assets that are unique and non-fungible units of data stored on a blockchain. This blockchain is just an advanced online recording system. NFTs can be created to transfer ownership of physical things or digital media, including, in this case, the image of handbags. These NFTs can be sold and traded in different digital marketplaces like OpenSea. Confusing, right? I know. But with that out of the way, back to the lawsuit. So again, Hermes is suing for trademark infringement. But what is trademark? In short, trademarks are generally words, names, symbols, designs, or any combination of them used in commerce to identify and distinguish the goods of one company from those of another. Trademarks are important because they indicate the source of the goods. A quick example would be the Apple logo. If you see these on a laptop or any product for that matter, your brain will automatically assume that the product is related to Apple. Most likely, you'll think they created the product. But what if they didn't? What if I made the calculator and called it the iCalculator and slapped the Apple logo right on it? People would still believe it's Apple's, and Apple won't like that at all because, well, what if my calculator is trash? Well, now you'll associate that bad quality to Apple, even though they didn't make the product. So by using their logo, I tarnished their brand a little, and this hurts both the consumer and the trademark holder. The consumer was confused and believed that they were getting an Apple calculator, which they probably expect a certain standard of quality that wasn't met with my bootleg calculator, while on the other side, Apple possibly just lost the customer. So as you can see, trademarks are very important, and companies do everything they can to protect them and make sure people aren't using them without permission. Well, as mentioned, the Meta Birkin's NFTs depicted Hermes Birkin bags, which are trademarked. Hermes cites social media posts and press coverage in the complaint to show that consumers were being duped into believing that these NFTs were created or at least endorsed by Hermes. They further argued that Mason is harming the brand's ability to enter into the NFT space with these NFTs. I don't know if you would really want to go into the NFT space right now, considering that the NFT market is down, but nonetheless, preventing a trademark holder from entering another market is something that the courts take into consideration when analyzing trademark infringement. But what else is taken into consideration? Well, let's quickly go through the elements that the accuser needs to establish in order to claim trademark infringement. Trademark infringement is governed by the Lanham Act. For registered marks, it's 15 U.S.C. 1114. Under the statute, the plaintiff must demonstrate that 1. It has a valid and legally protectable mark, 2. It owns that mark, and 3. That the defendant's use of the mark to identify goods or services causes a likelihood of confusion. Considering that Hermes is a well-known brand internationally and that their trademark is registered, elements 1 and 2 are pretty easy to satisfy. On the other hand, element 3 can be broken down into 3 separate components: defendant's use of the trademark, in commerce that led to a likelihood of confusion. Let's start with use. The alleged infringer must have used the trademark in some capacity. Here, not only do the images of the NFTs look exactly like the Birkin bags, although covered in fur instead of leather, it also uses the Birkin brand in its social media campaign and name of the project. This is likely enough to establish use. While in commerce means that the alleged infringer's use/activity must have a substantial effect on interstate commerce. This is also likely meant considering that he advertised and sold these NFTs, aka sold this product to several people and made a profit, thus commerce. Moving on to likelihood of confusion, well, this is where it usually gets muddy with cases of trademark infringement. A likelihood of confusion exists when consumers viewing the allegedly infringing mark, aka the Meta Birkin NFTs here, probably assumes that the product or service it represents is associated with the source of a different product or service identified with a similar mark, aka Hermes and its Birkin bags. Here, considering the goods in question are related but do not directly compete for sales, because I don't think anyone is buying a Meta Birkin as an absolute replacement for an actual Birkin bag, then things get even more complex. In these cases, the court looks at several factors. These are the strength of the trademark owner's mark, the degree of similarity between the trademark owner's mark and the allegedly infringing mark, evidence of actual consumer confusion, the marketing channels used, the types of goods involved and degree of care likely to be exercised by the purchaser, the alleged infringer's intent in selecting the mark, and other facts showing that the consuming public is likely to expect that the trademark owner is going to manufacture a product in the alleged infringer's market, or is likely to at least expand into that market. I know, it's a lot, so let's go through them really quickly and break them down. All right, number one, the strength of the trademark can be shown by how well known the trademark holder is, whether it be in a specific market or in general to the world. Here again, the Hermes and the Birkin bags are pretty well known. It's hard to argue that they don't have a strong trademark. Number two, this factor is one of the most important factors, and I don't want to oversimplify it, but well, here the similarities are basically the same. The design of the NFT bags are almost identical to the actual Birkin bags, and Mason straight up uses Birkin in the project name and advertisement. Now, a good lawyer could always make a decent counter argument by nitpicking every little difference, but as we'll get later into the case, it seems like Mason acknowledges the similarities and instead is arguing that he is allowed to use the trademark under First Amendment protections. So that leads to three. Evidence of actual consumer confusion. Okay, so here is where both parties go back and forth. As mentioned, Mason created domain names and social media handles bearing the Birkin moniker, which Hermes argues contributes to the consumer confusion. Surveys asking consumers if they would confuse the product can be used as evidence, and Hermes did so in this case. However, the parties clashed at trial over the reliability of a survey conducted by one of Hermes' expert witnesses, who found a net confusion of about 18.7% among potential NFT buyers, while Mason's expert witness said that the survey misclassified respondents as confused when they weren't, bringing the net confusion rate to 9.3%. Now, there's no magic percentage that the plaintiff has to prove since all these factors are taken into consideration, but it seems like most courts look for at least 15% to qualify it as a consumer confusion, which if Hermes' survey is correct, then it would definitely qualify as such. Number four, with regarding marketing channels, I would argue no, because it's not like the NFTs are being sold in the same place as Birkin bags. Now, you can argue that they can both be purchased online, but even then, they're not on the same websites. They are also tailored to different audiences. However, they are advertised on social media, but then again, so is everything nowadays, so I'm still inclined to say no. Alright, so number five. So this factor focuses on how much care the purchaser exercises when thinking about buying the product. The more sophisticated the potential buyers of the goods or the more costly the goods are, the more careful and reasonable prudent the purchaser may be. At least, that's the assumption. The logic here is that they would be less likely to be confused by similarities if they're more prudent purchasers. Here, I think you have good arguments for both sides. On the one hand, NFTs are expensive, but on the other hand, are NFTs really worth anything? NFT buyers would say so, but non-NFT buyers would likely say that they're stupid and dumb purchases, so I guess they can go either way. Okay, so number six is the intent of the alleged infringer. Unfortunately, Mason's key expert witness to support this argument was ruled that they couldn't testify in front of the jury by the judge. The witness was the famed New York art critic Blake Gopnik. Blake, who authored the 2020 biography Warhol, could have been able to establish a connection between the Meta Birkins and Warhol's art. In pretrial testimony, Gopnik argued that the Meta Birkins were in the vein of business art, a concept pioneered by Warhol, which, to be honest, is a concept I don't quite understand. I'm assuming it means seeing art more of a business than just art, but that's just my guess. Anyways, on the other hand, Hermes' argument is pretty straightforward in that Mason used the trademark as a way to associate itself with the brand and used the brand as a way to make money selling its NFTs because, well, the appeal of the NFTs probably comes from the fact that it's a famous handbag instead of a random bag that no one's ever seen. The last factor is the seventh factor, which just gets to what we were saying at the beginning, that Hermes is likely going to expand into the NFT marketplace, and these Meta Birkins are hurting that expansion because they will be associated with Hermes even though they have no relationship whatsoever. Evidence of this is that other brands and fashion houses like Louis Vuitton, Gucci, and Nike already began selling their own NFTs. And it makes sense that Hermes would like to follow. And with that, we're done with the 7 factors. And yeah, I know that's not as quickly as I hoped, but unfortunately there's more because on top of the plaintiff's allegations, the defendant, aka Mason, can now claim defenses. And here, his biggest defense has to do with the Rogers test. Now, throughout the case, Mason argued that his NFTs are works of art protected by the First Amendment, no different than Andy Warhol's famous silkscreen prints of Campbell's soup cans. Now, Mason's attorneys categorized the NFT project as an artistic experiment that examined how society places value on status symbols. In order to find out if it's a protected expression, you apply the Rogers test, which is a free speech trademark rights balancing test. It comes from the 1989 case Rogers v. Grimaldi, which allows artists to use a trademark in their work without permission as long as the use has 1. Minimum level of artistic relevance, and 2. Doesn't explicitly confuse consumers. The first prong's threshold is very low. As long as it's above 0 level of artistic relevance, it's fine. Here, Mason's characterization of his NFT project as an artistic experiment that examines how society places value on status symbols could possibly be enough. The second prong, explicitly misleading, refers to an obvious and unambiguous statement of sponsorship. What is considered explicitly misleading varies from court to court. Here, we're in the Second Circuit, and according to the Twin Peaks production case, the rule for this prong is to use the heightened threshold of likelihood of confusion factors, which we've already mentioned and did. And why are they heightened? Well, because it has to do with First Amendment rights, and anything that has to do with the First Amendment tends to have a sort of heightened scrutiny. And since we've already went through the factors, it seems like, yeah, that Mason's NFT project likely does explicitly mislead consumers. However, Mason doesn't think so. He believes that his NFT project is protected under the Rogers test. He went as far as to file a motion to dismiss last February on the grounds that his NFT passed the test. The judge was unconvinced and stated that even though the Rogers test is likely the right test in this case, it needs more factual information to evaluate. But there's one more thing about the Rogers test that I didn't mention. Back in November, the US Supreme Court decided to hear a case that will probably help define the boundaries of the Rogers test. In that case, Jack Daniels sued a dog toy maker called VIP Products for making a chew toy in a distinctive shape that looked exactly like Jack Daniels' whiskey bottle. It even has poop-related puns based on the actual product's labeling. Now, VIP Products is arguing that the toy is just a humorous parody that is protected under the Rogers test. But I guess we'll have to see about what the Supreme Court says about this. What they end up deciding will probably provide guidance on how the Rogers test will be applied to future appeals and new NFT cases. Regardless, if Mason wins in front of the jury, the fact that this suit made it all the way to trial is probably going to shake the NFT art community because it essentially is signaling to them that incorporating trademarks into their work could lead them to getting sued. Okay, so hi, this is Future Eduardo. The 9-person jury in this trial returned a verdict awarding Hermes $133,000 in total damages, which isn't that much all things considered, but more importantly, they found that the NFTs aren't protected speech under the First Amendment. And considering that this trial was the first to ever examine how NFTs should be viewed through the lenses of intellectual property law, it definitely has left its impact and precedent for future similar cases. Bye.